Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to our special podcast episode about the new unfair contract terms regime that is coming into force in just a few weeks on the 9th of November to be exact. My name is Susie Leask and I'm a partner at Hall and Wilcox. Today I'm delighted to be joined by my colleagues partner James Deedy and special counsel Mark Levin to discuss the new unfair contract terms regime. Mark and James, welcome.
Thanks, Susie. Great to be with you.
Now, these are significant changes to the unfair contract terms regime for both business contracts and financial products. These changes not only broaden the scope of contracts captured by the new regime, but they also introduce significant penalties. Businesses that use or enter into standard form contracts are really likely to be impacted by the unfair contract term laws. Now, Mark, James, I think that's just about all businesses, just about. Mark, can you run us through some of those new significant changes to start us off?
Sure, Susie. I think perhaps the most significant change for people to be aware of is the introduction of some significant civil penalties. This regime has been around for quite a number of years, but there weren't any civil penalties for breaches, which is now changing. So from November, the penalties are quite significant. For companies, the greater of $50 million, 3 times the value of the benefit obtained, or if the value of that benefit can't be determined, 30% of the company's adjusted turnover during the breach turnover period. And for individuals, penalties of up to $2.5 million. So really significant penalties, which really should sharpen everyone's mind in relation to these laws.
And that's per contravention. So every time they have an unfair contract term in their contracts, is that right?
Yeah, that's right. So the penalties can really build up really quickly if you have a contract that has quite a number of unfair terms in it. So it really does make the consequences of breaching these laws really quite significant.
As Mark said, they're really significant changes to penalties, and I think it's been a regime where I think the regulators have been frustrated by the lack of penalties available, and I think what we'll really see is a bit of a shift in mindset around compliance with unfair terms, similar to the changes that we saw when penalties for contraventions of privacy laws came in. For example, it went from being sort of an issue around what are the consequences reputationally if you breach, as opposed to actually being liable for penalties. And I think we might see something similar with unfair contract terms.
James, I completely agree with that. And I know the ACCC and ASIC have both come out as the regulators and said that they will prioritise these new unfair contract laws and enforcement of those new provisions. And essentially, I think they have a new big stick in the form of new powers and new penalties. And so, like all regulators, they're going to want to use them. So, Mark, can you walk us through some of those new changes and how the new laws will work come 9 November?
Sure. One of the other big changes that's coming in is what will be a small business for the purpose of determining a small business contract. So previously or currently, to be a small business, the relevant business had to have less than 20 employees, and also the contract had to have an upfront price which didn't exceed a specific threshold. Now, from November, that's changing quite significantly. So to be a small business contract, one party of the contract now just has to be a business that employs less than 100 people or has a turnover for the last income year of less than $10 million. And there's now no monetary threshold. So you can meet the small business contract by meeting one of the 2 thresholds, having less than 100 employees or a turnover of less than 10 million. And I think what will happen is there'll be quite a number of businesses that qualify under these tests will be significantly increased. So the scope of an application of the laws will apply to a lot larger number of contracts than before.
So less than 100 employees and less than $10 million in turnover. I think that's a lot of businesses out there that's going to be covered by these new laws. And tell me, what exactly is a standard form contract in terms of the application of these laws?
The laws apply to 2 types of contracts, a consumer contract or a small business contract. And there's definitions of that in the Act. But once you've got a consumer contract or a small business contract, it also has to be a standard form contract for the laws to apply. And a couple of important things to note in terms of standard form contracts. Firstly, there's a presumption that courts have or take that a contract is a standard form contract. So it's So it has to be rebutted. And secondly, there's no definition expressly set out in the Act about what a standard form contract is. There are a number of presumptions that a court will consider, including if there's uneven bargaining power, if a contract was prepared without or before discussions between the parties, if there's little or no opportunity to negotiate. And I think one of the important differences, though, is that a standard form contract isn't necessarily the same as a template contract. Lots of businesses out there will have a set of template contracts or agreements that they use, and just because it's a template won't necessarily mean that it's used as a standard form contract. So each circumstance will differ, and you need to consider that when trying to determine whether the laws apply.
And James, just to clarify that point, if I'm a business and I negotiate my standard template form contract, will the laws still apply to me in terms of the new unfair contract terms regime?
In the event that you negotiate the contract, then in all likelihood that won't be a standard form contract. I guess where it's more challenging is, as Mark has sort of mentioned, is that the definition of when something is or isn't a standard form is not entirely clear, and there is that presumption. So you've got to essentially rebut the presumption. So what we find is that it means for a lot of organisations that, you know, the circumstances where they might negotiate sometimes, but they might not negotiate on other occasions, then that can be a tricky situation as to, well, you know, do you need to be thinking about unfair terms compliance to cover off on those situations where a contract that sometimes is negotiated might, for, you know, in other instances not be negotiated, where there's a lower value or it's a higher volume type situation. So it's the sort of lack of clarity around that definition and the rebuttable presumption do make it sort of, combined also with penalties for non-compliance now, it does make it a slightly trickier question for organisations around identifying exactly when they've got a standard form contract to deal with.
And I think it's important to note there are a few changes been introduced around some additional presumptions that a court can take into account, and one of those is whether the ability to negotiate was only for a minor or insubstantial variations. And I think that's important because some of the case law to date has really focused on the ability of parties to have an opportunity to negotiate as rebutting the presumption. And the view the court took was, as long as you're given the opportunity to negotiate, it doesn't matter necessarily what you were able to negotiate, just that the opportunity was there. But these new presumptions may have been the courts take a different view, and so provides a little bit more uncertainty about what the courts might say in the future.
And that's really interesting, Mark, from the perspective of, say, an in-house counsel, for example. You can't just say, oh, they had the opportunity to negotiate anymore, or make a tiny, minor or insubstantial change to get it outside of those new provisions. I think that's a really interesting clarification to these laws, in that it's not so easy to step outside of them if you just negotiate a little bit.
Yes, I think that's right. I think the courts still won't require you to agree to changes because the party raises them, but you need to at least, I think, genuinely engage in that negotiation process and not put up a brick wall.
So, Mark, for the benefit of our listeners who are not as familiar with the laws, talk us through what is unfair. What would be considered an unfair contract term?
Sure. So the test of whether a term is unfair or not hasn't changed or isn't changing. So for a term in a standard form business or consumer contract to be unfair, it must satisfy three things. Firstly, the term must cause a significant imbalance in the parties' rights and obligations under the contract. Next, the term must not be reasonably necessary to protect the legitimate interests of the party who would be advantaged by the term. And then finally, the term would cause detriment to the small business if it were to be relied upon. And here we're not talking just about financial detriment. There could be other detriment such as delay. And the detriment can be trivial or insignificant. It doesn't have to necessarily be material.
So, Mark, if we put that another way, if there's no significant imbalance, we're fine. If there's no detriment, then it might not be unfair. And the one that I really think is interesting from a case law perspective is that legitimate interest that you're trying to protect. And I think that's a really commercial perspective that you have to take in terms of justifying it. And the case law that I've seen that's fascinating is actually not the ones where the ACCC say is successful in saying something's an unfair term, but where they've been unsuccessful and businesses have defended it on the basis that there might be a financial or other legitimate business interest that they're trying to protect in those unfair contract terms. James, can you give us some insight into the types of clauses that have been held to be unfair by the courts?
Yeah, definitely. So we've had some form of unfair contract terms laws on the books really since 2010. So there's been a fair bit of case law, enforcement decisions and the like around the types of terms that can be a problem from an unfair terms perspective. And so I think there's really sort of two categories of clauses that have been held to be unfair terms. There's a category where when you look at it, it's not that surprising when you think about it that the clauses were held to be unfair. So things like unilateral variation clauses. So clauses just allow one party to change the price of the contract without having to get consent of the other party. Things like overly broad termination rights that make it really easy for one party to get out of the contract, but make it pretty hard for the other party to get out of the contract. Overly favourable liability and indemnity provisions that really protect one party but leave another party sort of more exposed. So they're the sorts of clauses, and there's many other examples where they've been held to be unfair, and you can really sort of understand the problem with some of those clauses. But I think there's also a category which is some clauses that have been held to be unfair that when you sort of first look at it seems a bit surprising. So a good example of this is an entire agreement clause, really common clause in contracts, which basically says that the contract represents the whole of the agreement between the parties. Now, those terms have been held to be unfair, potentially, because they exclude pre-contractual statements or representations that consumers or small businesses may want to rely on. And there's other similar examples around some exclusivity provisions, for example, have sometimes been held to be unfair terms in certain contracts and then held not to be unfair in other contracts. So as you say, Susie, the interesting area can be, well, where is a term held to be unfair in one case, but potentially not unfair in another? And there's definitely lots of examples of where that's occurred.
And that's really interesting, James, from the perspective of business owners and people who are drafting contracts day to day in terms of how we look at contracts as a whole. And that is one of the elements that we have to consider when considering whether a term is unfair. And Mark, I wonder if you can elaborate a little bit on the approach that we're taking and that we're seeing businesses take around the drafting to mitigate some of these unfair contract terms risks.
I think it's a really nuanced approach that you take when you're reviewing potential unfair terms. So it's not necessarily simply a case of just identifying a potential unfair term and crossing it out and deleting it. As I said, you've got to look at whether there's a legitimate business interest being protected. And if a clause is potentially unfair because it's so broad, or it's a unilateral price variation clause, which allows a party to vary a price for any reason, that's probably going to be unfair. But if the intent of that clause was to simply allow for CPI increases, then if you draft the clause more narrowly to just allow for CPI variations, then it's less likely to be unfair. And the courts are probably going to say, well, we can see what the legitimate interest you were trying to protect was. It was changes in CPI. So when you come across a clause that's potentially unfair, you really need to engage with the people in the business to understand why that clause is in there and in what circumstances they may or may not rely on it. And if you get that information and get that understanding of the business and why that clause is there, often you can actually come up with a way to refine the clause so that it probably won't be unfair. And what you're doing in that case is you're not only reducing the risk of the term being unfair, but you're not really changing the business's position because you haven't struck out the clause. It's just now reflecting the way in which they will most likely rely on it or want to use it. So it's a really important and sometimes nuanced approach that needs to be taken when reviewing and then amending contracts for unfair terms.
So we're essentially, as part of that contract review process, almost building our defence, aren't we, in terms of going, that's not significantly imbalanced, or this actually is necessary to be included in this particular contract for this particular circumstance in this business in order to protect that legitimate business interest, which I think is a real challenge, wouldn't you agree, James, from a business owner's perspective, because there is no one size fits all approach and there is no sort of tick box, yes, this contract is now fair, as part of our review as legal advisors.
I think that's right, Susie. I think that, unfair terms really requires quite a different approach from business owners, but also from lawyers. As lawyers, we like to draft things really broadly and try and cover off every eventuality. Sort of, Mark's given a really good example of a price increase clause, and you might traditionally draft a really broad price increase clause to try and cover off everything. But in an unfair terms environment, that can be challenging in terms of enforceability. So you need to sit down and work with business owners and really identify what are the real risks that we're trying to use this clause to cover off, and how can we sort of justify that as being a legitimate interest. So it really involves a bit of a change of approach, even from a lawyer's perspective, and also from a business owner's perspective in terms of how you approach some of those contract drafting issues.
And if I can play devil's advocate for a minute, I think there's a lot of businesses out there who, given we're talking about business to business contracts, for a lot of these and more are going to be covered because of that small business definition expanding so broadly. What do you say to, I guess, those business owners who think it's a little bit unfair to have these regulatory regimes come over the top of their commercial contract processes?
I think probably the answer to that is that while you need to be aware of these laws, it's not going to apply to every contract you have or every contract you enter into. There's a number of thresholds that have to be met before you get to an adverse finding. And the main one is, I think, it's got to be a standard form contract. So if you're a business and you have a contract and it's a sort of a template-based contract that you send out for a type of transaction, and you send it out on a take it or leave it basis, then you probably do need to be a little bit concerned that the laws may apply and need to ensure that those contracts are compliant. And you can see why the ACCC is trying to protect maybe businesses that don't have the power to negotiate or that feel like they don't have any power to seek variations. But if you're a business using a template contract and you're allowing and you're reflecting commercial arrangements that have been agreed with another business, and then you send that agreement off to the other party and let them review it and provide feedback and engage in negotiations if they wish, then there's a good chance that these laws won't apply. So I think the message to all businesses, you need to be aware of these laws and be mindful of when they might apply, and really, I guess, do an audit of your contract that you have to try and identify where they may or may not apply. Because on first blush, you might think, geez, this is going to really impact how I contract. But when you get down into it, it may not be all your contracts are subject to these laws, but there are maybe a few key ones that you need to review.
I think, to Mark's point as well, these laws don't mean you can't ever have a certain type of clause. It doesn't mean you can't ever have a price variation clause or you can't ever have a termination clause. It just might mean that that clause might need to be a bit narrower than it had previously been, or there might just need to be a bit of thought put into how do we draft it in a way that reflects sort of a more balanced position potentially. So, it's not the case that you have to throw out all of your contracts or anything like that, but it does mean that, it might just need to be a bit of thought around, the contract terms and how they're drafted and how they're presented to your customers and your clients.
So, James, the three of us review a lot of contracts and are doing a lot of these unfair contract reviews. How are we helping clients, and what are you seeing in terms of the trends and some of the approaches that are being taken to these unfair contract term reviews?
Yeah, definitely. We're obviously reviewing lots of contracts from an unfair terms perspective at the moment. And so one of the things that we've found from those reviews is that they can be, a really useful exercise. And I know that, a lawyer saying that reviewing a contract is a useful exercise might sound a bit unsurprising. But what we do find is that when you go through these contracts, there's sometimes clauses in there that clients will say, well, actually, we've never used that, or I'm not even sure why that clause is in there. It's just sort of always been in there. And so there can be a process sometimes of simplification, of saying, well, we don't need some of these clauses in there. We can actually simplify the contracts, make them easier our customers to understand and hopefully reduce a bit of friction in terms of the contracting process and make it easier to get sort of contracts signed and accepted by customers. So we're definitely seeing that. I think the other thing that we're seeing a lot of is that, you know, it's a really useful exercise to sort of think through the reasons that particular clauses are in a contract, because sometimes, you know, the clause might actually not cover the risk that the business is really concerned about, and might cover a different risk or something like that. So it can actually result in a better contract that actually genuinely covers off risks that people are particularly concerned about, versus something that, you know, is sort of broad, or something that's just sort of been there because it's always been there.
So it's quite a commercial and pragmatic approach. And I guess I'm also seeing it as a risk management approach, where different businesses have different risk profiles. And so some will be very conservative to avoid regulator scrutiny, and others will want to push the envelope a little bit more to protect some of those commercial interests. What about you, Mark? What are you seeing?
Yeah, I agree with what James has said there. I think what we're finding is that clients, there haven't been many times when we've said to a client, look, we think this term's potentially unfair, and we haven't been able to come up with a way to either they sort of said, look, we don't use that term, or we haven't come up with a way where we can make it reflect more legitimate interest and how they use it. So we're not finding, I guess, many cases where there's just the lawyers are saying you can't have that clause, and the client or the business saying we need it, and there's a impasse. But we're finding that there's always a way through, and always a way to protect the client's interest, but also make sure the term is sort of less likely to be unfair. And I think from that point of view, that the reviews that we're doing, they're not so much of to be feared as a compliance, big stick review. They're a way to help improve the contracts in many instances. As James mentioned, it might help reduce some of the friction points that businesses have with their other contracting parties, even if they're not negotiated. Having overly one-sided indemnities that are never used may cause friction when in reality there's no need for that to happen. So I think what we're finding really is that the way these reviews play out is that they're really helpful and really help improve the contract without really requiring a business to give up too many significant rights.
Completely agree, Mark. And I think as we look towards the 9th of November, which is fast approaching, I think from a regulator perspective, the ACCC and ASIC have come out and said there's been 12 months to transition and get ready for these new laws, and it's very much an enforcement priority. And the ACCC has said they've long advocated for this change, and it's no surprise that they will be prioritising compliance with these requirements. And I think there's that view from the regulators that for too long businesses have failed to take the unfair contract provisions seriously, and now they have these penalties in place for exactly that reason. And it is going to become a really important part of businesses' risk and compliance program. So to wrap up, James, Mark, how can businesses get ready? What should they be doing now?
I think that there's a number of ways that sort of businesses can get ready. I think that there's sort of a review of your contracts approach that you can take, and I think that there's sort of 3 stages to that. There's sort of an identification stage, so just identifying all the contracts that you enter into, and then the second stage is often to sort of work out which of the contracts are potentially subject to the unfair terms regime, because there might be some that are heavily negotiated, there might be some that are never entered into with small businesses or consumers, and so you might be able to rule some out as being actually not subject to the unfair terms regime. And then the sort of third part of that process is often the review process. So having a look at the clauses, identifying where we think there's an unfair terms risk, and either seeking to remove the provision if people think it's not necessary anymore, or amend it to try and sort of adjust it or reduce the risks, or sort of address the legitimate interest that the clause is seeking to protect. So I think it's really that the first sort of piece is just being aware of the fact that this is coming in, and then the second piece is, well, how do we actually have our contracts assessed and looked at and make sure that we're ready for the changes.
And I think that the last piece in the puzzle is really diarising in a year, 2 years, whatever it might be, but on a regular basis to review these contracts, because there's case law all the time in this area, and things are changing, and our understanding of where the limits lie, and also what type of clauses are sort of the regulators feel are unfair is changing, and we're learning that all the time. So I'm regularly reviewing these going forward. These sort of contracts, I think, will be important to make sure that the contracts remain fit for purpose.
That's a great point, Mark. We are certainly seeing lots of case law on this in terms of how courts have applied these laws, and it's certainly going to be an interesting space to watch going forward to see provisions that haven't previously been found unfair in particular scenarios could be unfair, particularly in these new provisions, which are so much broader. Thanks everyone for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, including our Unfair Contract Terms Resource Centre, or connect with James Deedy, Mark Leban, or myself, Susie Leask, on LinkedIn. If you enjoyed today's episode, then rate, review, or follow our podcast wherever you get your podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.